Okay, make a motion, please.
I make a motion that the minutes be accepted as distributed.
Second, please.
Second.
All right, discussion? No comments? All in favor?
Aye.
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 Opposed?
Aye.
Accepted. Okay, so we have we've got two guarantee funds today. Annalisa, you're here.
I am here. Good morning, Mr. Chair.
Good morning. How are you?
Good.
Great. So I'm just gonna ask a few questions and then we'll let you take us through this, okay?
Okay.
So the applicant has, it's been within 2 years, am I correct?
That is correct. Yep.
Okay. So the real estate broker or real estate salesperson or unlicensed employee of the licensed broker or salesperson was found to have done any of the following: investment of money on or property, taken money or property unlawfully from any person by false pretenses, artifice or trickery or forgery, engage in fraud or misrepresentation. We have a certified, will you have a certified copy of the court judgment? Which must be attached to the application, which it was, I assume.
Yes, that one was.
Okay, if you're eligible, let me see. So they're eligible for fund reimbursement for the amount of no more than 25,000.
Yes.
Okay. He's aware that they're aware of the fact that they can only recover actual damages costs.
Yep.
We
Both.
need-
So, yeah, both cases are aware that they only get what is authorized in the court documents.
Okay, we've attempted to collect the money owed you by means of sheriff's writ of execution and have been unsuccessful in that attempt.
That's correct.
Okay.
Yeah, for both of these cases.
Okay, both, have we checked and make sure there was no assets floating around here? Is these individuals?
So both of these cases came back with unsatisfied writs of execution. The first case, Mr. Layton's case against Mr. Malcolm, that one I believe had the I'm pulling up my documents here. The unsatisfied writ against the accounts, and I'm sorry, against both the accounts and the property. And the second case against
Could you explain that, please? Exactly what does that mean?
Okay,
Because
so
there was funds available in those accounts?
no, so those, so the each, so the first case here, which is Mr. Layton's application against Mr. Malcolm, these have both an unsatisfied writ of execution against property and against accounts. Usually we just get them through against their accounts only. The courts do not allow both of these documents at the same time. So you have to do one, go through the full process, go back and do the second one, go through the full process. The court will actually kick it back if you try to do them at the same time. So it ends up accruing additional fees that the applicants are unable to request. So usually these applications have been coming to us with just the unsatisfied writ against the accounts. Did I answer your question?
I think so.
Okay.
I think so. Okay,
Ben,
yeah, go ahead, I'm sorry.
I don't quite follow. I mean, I see the order and I see what the judgment and all that was, but could someone, maybe, and Elizabeth, explain just briefly what the transaction was?
Yeah. So the talking about the first case here, this is the 2025-28, which is Mr. Layton's case against Mr. Malcolm. This is a very complicated court case. I'm going to pause 1 second because I heard somebody talking. Is that Mr. Layton on the phone?
Yep, I'm on the phone.
Okay. Actually, Mr. Ellis, would you like, Mr. Layton's here online. Would you like him to explain it or would you like me to go forward with that?
Either one. Just as long
Okay.
as,
Okay. I'll start real quick and Mr. Layton can correct anything that I say here. This was a case against a seller and a seller's company and the agent over failure or not failure to disclose, but they said that a property was on public sewer. The condition report said that the property was on public sewer when in fact it was on septic. And so the case turned on the condition report failing to disclose that material fact that it was on a septic, and therefore Mr. Layton, the purchaser, had no indication that he should request a septic inspection, and it turns out the septic system was actually failing. So that was the basis of the court case. The judgment came down as a default judgment against Mr. Malcolm because Mr. Malcolm did not respond to any of the pleadings, and the court awarded a default judgment against him for most of the damages, I think possibly the entirety of the damages based on the septic system, the failing septic system, and the damages resulting from that, and the cost of putting in a new septic system. So that is why the judgment is particularly large, because Mr. Malcolm is defaulted and is therefore on the hook for the failure to disclose the material fact of the septic system. Mr. Layton, if I hit that correctly?
Yep, that pretty much covered everything.
Okay.
and Mr. Malcolm was the broker and seller, or just the broker?
I believe
He was
just
an attorney. Yep.
I'm sorry, Mr. Malcolm is the person, he was the broker.
The
Yeah,
broker,
Was he
was
also-
he?
Was
he was the
also-
broker on the transaction. The seller was a separate, and that's why the court judgment refers to D3, defendant 3, because the first two
Okay.
defendants were the seller and the seller's company.
What's the total amount that you're applying for between both judgments?
I believe it's 25,000.
The judgment,
The maximum
and-
amount is, yeah.
yeah, exactly. The judgment is far exceeding the amount. So at the application is for the full 25,000 authorized from the guarantee fund.
The cap, okay.
So again, the defendants were J.C. Home Improvements, Mr. Malcolm, and who was the other one?
Let me pull. Mr. Layton, do you remember the names of all the defendants off the top of your head?
It was Mr. Malcolm and Mr. Etienne.
Who was that?
And
Etienne is he's the listed seller. He flipped the house.
I see, okay, all right. Thank you.
I'm sorry, again, where was the proof that Mr. Malcolm was aware of the faulty septic system? Where was that?
During
What was
the
the evidence of such?
during the court proceedings, he said during it that he was aware and that he just signed off on the papers, and that was that.
Wait a minute, he was a broker. What papers did he sign off on?
The disclosing documents.
So he was the seller also? The seller signs off on the disclosure.
Or rather,
just
so
don't-
he was reviewing it all. He went through it. He's told during the course of the proceedings, he stated that he was aware of the system, and he just he okayed the disclosing documents from Mr. ETN, negating the fact to actually go through them thoroughly. And that's pretty much what he said.
And there's no possibility of collecting?
He
sorry.
hasn't responded in any proceedings at all.
If we go forward with awarding this, is Mr. Malcolm's license revoked?
That's
Because
those
he's a
guys.
licensed broker right now still.
Yeah, so what would happen is the guarantee fund claim would be, he would have to reimburse the guarantee fund for the claim
To
before
reinstate
being
his
able to renew
license.
his license.
Yeah, okay, thank you.
And my understanding is that, so yeah, the seller was the one who completed the disclosure report stating that it was on town sewer, but that the broker also knew and did not contradict the seller. And the question of whether the broker had a duty was not litigated in court because it was a default judgment, but he still failed to disclose this. It is a pretty, material fact, whether it's on sewer or septic. So that's how this came before today. But because it was a default judgment, the court did not weigh in on the evidence that, there's no evidence on the record that you're asking for because it was a default judgment. He just didn't show up. He didn't answer the documents and the court ruled against him because of it.
So it was a default judgment, you said, and there's also, did you say was levied on the property or levied on something of the brokers?
Against, so these writs of execution, this is where a state marshal, the court gives a document saying you can collect this court judgment against this person's assets, and you give it to a state marshal. The state marshal returned these writs as unsatisfied, saying that there was no assets available to claim against on the part of the
Right,
broker.
good. Maybe going forward, it would just be helpful to me, I don't know, with the rest of their commissioners, if we could see the complaint on these, that certainly you could sort of explain exactly what the transaction is. And I suppose if there was a writ, there were writs, we could either
Yeah.
know that or have a copy of that.
Yeah. And the writs, the documents that Rochelle sent with the links in the file, the second file has the contract and the judgment and the writs in there as well. The complaint itself, I did not include because this was a very complicated court case. The original complaint in this court case was against the seller and the seller's company. The broker was brought in on a counterclaim.
Okay.
So
Yeah.
I could either provide you 100 pages of documentation or exactly.
Yeah.
So this
Yeah,
was
I
an
guess
immensely complicated. Yeah.
Yeah, I must have missed, I missed, all I got was the application and the order, the judgment. So I must have missed
Okay.
something
If-
there, but okay.
When you
Yeah.
click into that judgment, if you scroll down, it should have been after the judgment itself toward the end. If you're not seeing that, I apologize.
Okay, all right, okay, you're right. How did I miss that? Yeah. There's a contract. The contract is there.
The
Is there a
contract is there. And if you
I see,
keep
but-
going past the contract, you're going to see the writs themselves, the execution, and then there should be an
okay.
unsatisfied note from the state marshal.
Okay, yeah, I do get that. You got the one I was missing was the complaint. Yeah, okay. Okay.
And that's simply because this was such a complicated court
Right,
case
I
with
understand.
the,
Yeah.
Yeah.
Okay.
Has there been any money paid on this issue at all?
I do not believe that Mr. Malcolm has paid anything against this judgment. Mr. Layton, is that correct? Not sure if he can hear me. But yeah, I do not believe anything has been paid toward this. It said the writ of execution against the accounts, meaning the state marshal's attempt to collect the judgment against the bank accounts held by Mr. Malcolm, was returned unsatisfied, so nothing was paid out toward this.
Yeah, Mr. Malcolm hasn't paid anything to this date.
Okay.
Thank you.
And Mr. Malcolm is not here today.
That is correct.
Mr. Malcolm was aware of this hearing, or excuse me, meeting.
Mr. Malcolm was aware of the attempts to collect against him. He was aware of the default. He was properly noticed by the court of the judgments and the writs of execution against him, and failed to respond.
We have all the receipts of that.
Yeah.
Okay. Any other questions? Nobody has any other questions? Then if so, then I need a motion. And then I'll need a second after that.
For purposes of further discussion, I move
Well-
that we
Okay.
approve the request.
I second the motion.
Discussion? Further discussion? All in favor?
Aye.
Aye.
Oppose? Pass. Accepted. Okay. That's 25,000. I think he had asked for, oh, yeah, that was 25,000 maximum anyhow, but I think he sold, what, 61,000 to 62,000? All right, Mr. Lightning, I wish you the best. Thank you.
Thank you.
Mr. Chair, is it okay if Mr. Layton signs off at this time?
Yes, he can.
Excuse me? She's gone. Yeah. Is that a Navy cap I see behind you?
Yes, it was NOAA Corps. I'm still here. I was active duty for almost 16 years, so it was.
Thank you
Yep.
for your service.
Thank you very much. This is my law school was my midlife crisis.
All right,
But
A good
Mr.
one.
Layton, thank you so much, and we'll be in touch on the next steps.
the next one is Michael May. Can you tell us a little bit about this one?
So this is the second case. This is 2025-38. This is Mr. Sotire, represented or by his uncle, Mr. DiCarlo, against Mr. Ma. And they are both online if you have any questions for them. But this came out of a leasing case. This was failure to properly refund a full security deposit. Went through court. They received the judgment. The landlord is operating under the authority of his real estate salesperson license.
Do we have his license number here anywhere? You know, I guess my only thing, this format, the second one versus the first is different. And so it's a little difficult to follow it.
That's correct.
But where's his license number?
So this is the first one came in as a paper application, which the department is slowly removing paper applications. We still accept them, but we are also in the process of moving to online applications. So the second format, the reason that is how an online application is showing up. So in the very top, if you're looking at the application itself, in the very top section, it has Michael Ma, it has his address, and if you go down the very last line before complainant, that is his salesperson license number right there.
Is he currently still licensed? Jill, is he
Yes.
licensed?
Yes, he is currently still
He's
licensed.
currently still licensed. What is it?
Actually, can I ask a follow-up question from the question I asked before regarding licensing for these folks? they can't renew their license without refunding the guarantee fund, but is their license canceled in the meantime?
No, they are still able to practice. The department is also doing a separate investigation into this individual to look at whether there is enforcement action necessary against the license beyond the guarantee fund claim.
Okay. All
You
right,
know,
thanks.
what about his broker?
Well, Ray Malcolm is a broker.
So we've shifted cases now. So we
I
are,
understand that,
yeah,
but it's,
exactly.
but in any case, for any of these guarantee fund
Yeah,
cases,
no, but this Tataria, I mean, he was not the, I'm sorry, May was not, he's a salesman.
he's a salesperson. That's correct. And he's
Hmm.
operating under, I looked it up. And as Mr. Satire and Mr. DiCarlo are on, if they can recall his broker off the top of their heads.
I believe it was.
I can't.
That what you have?
Is Joe
I'm
here?
not sure.
Joe, can you just find out who he's holding his license?
Yeah, I'm here. Yes, I will. You're talking about Michael, right?
Yeah.
That's good. Yeah.
Okay, so the
Michael?
broker is, hang on. Oh, he says expired application. Interesting. Michael, hold on. Let me go back to this one.
You say expired application
Well,
for
no,
being broker
hold on.
license?
Supervised by Portunes, Portunes LLC. Let me see who that is. Owners. It's a broker out of Darien, Portunes LLC. They're an entity. And the designee. Ling Zoa, ZHA. That's the broker.
Let me ask you something. Why aren't they involved in this? I mean, the broker is responsible for the actions of his agent.
Correct.
Why isn't he involved here?
The short version is because the court judgment is against the salesperson.
Mhm.
And the salesperson's failure to comply with the laws on leasing and renting apartments. And the broker will most likely, if there is enforceable, an enforcement action necessary during that, if we can cover further violations during the investigation, the broker would be involved at that time. But in terms of the straight guarantee fund application, it's because we're going off the court judgment.
Well, I feel that there definitely should be an investigation regarding this and the broker is responsibility for the action of his agent. Although this has no effect on this right now. Go ahead, I'm sorry.
It's okay. I have a question though, so Michael is an agent and is he also the owner of the building? Or I'm a little confused as why the judgment was against an agent and not the broker. Right? Does anybody agree with that? I'm a little confused.
No, it's not the first time this has happened. They actually, it's the salesman who did the action of the salesman. The broker is the responsible person. That's a license thing I'm bringing up, and we'll deal with this later. This is already, we're concentrating and focusing on right now is the guarantee funds. And the claim. All right. So we will though get into the other. I will talk to the department regarding it. And I'm sure the department's already, I think, and Lisa has already said, the department has gone ahead and started investigating. Am I correct?
That is correct. That is with the real estate examiners right now to see if there's any violations there. And to answer yes, this individual is the owner, but again, also operating under the authority of his real estate license to do the leasing, not just as owner, because there are multiple properties. And his
And then-
license is also listed on the real estate documents.
How much are we looking for a claim here?
1,300, isn't it? Is it 1,300?
It's the 1,300 plus the fees. So if
I
these
thought, I thought we couldn't do it for-
documents,
Yeah,
when you go to the writs themselves, there'll be a court judgment. And then when you go to the writ itself, it will actually authorize additional fees. So in this case, if you're in the second document, not the application, but the second document with the judgment, and then you go down to the unsatisfied writ bookmark, or scroll down to that if you can't see the bookmark. In that writ, so I am on page 14 of the judgment and supporting documents document in the folder. And down there, you can see that there's a total of lines 4, 6, 7, and 8 of $1,405, $1,405. That is the claim, the amount that they can claim authorized by the court that includes additional fees.
In the application, it says 1,300 plus costs, plus double damages. So that's you say the total is 1,400 and something?
What the guarantee fund can, or what the department and the real estate commission has authorized is only what the court has said is collectible. And the court has said that the 1,300, which was the award and the judgment, and then the additional fee for filing the writ, which is an
Yeah.
additional $105. That's the only amount authorized by the court. That is the 1,405. And that's what we would ask for today, because that's what the court has said is recoverable.
is that,
Okay.
is that acceptable then? It's acceptable?
The 1,405?
Yeah, yes.
Yes. Yeah.
Okay.
And
We're talking
unfortunately,
14.
unfortunately, until the court authorizes the state marshal's fees as additional collections fees, at the moment, it's only the filing fee that has been included.
Okay, for a motion and a second after, please. Motion, please.
Do we need an explanation, do you think? I mean, I know we've all read it, but I wonder whether it would help if we had an explanation. Would that help anybody or not?
I think we can go with the explanation somewhat, but I mean, the bottom line is that it's been done by the judgment, I guess is the end part of here. So it's totally up to you, members.
It just seems strange that someone should come to the guarantee fund for an amount of money that normally could be handled within a business.
And this application does have as well, again, that unsatisfied writ, the attempt with a court authorized writ to recover the judgment against funds of the salesperson. And that was returned unsatisfied, meaning that the state marshal was unable to locate accounts with assets that the court could seize.
Right, again,
Does this go back to 2019? Is that the date?
The lease, and again, Mr. Satire, so Mr. Satire was the individual who had the lease, and then at the end of the lease, the salesperson did not return the full security deposit despite his failure to properly document, that the damages he was claiming part of the security deposit were from the previous tenants, not from Mr. Sotire. So the lease began in 2019, which was the initial part of that. The court documents, the court judgment was ordered in 2022, in March of 2022, but the court case was ongoing. So this judgment, even though that date is a little bit older, the defendant asked to have it reopened. The court considered it. The defendant, I believe, did not show up or failed to show cause, and the court reissued the judgment at a later date. So we're still within the 2 years.
Thank you.
Yep.
So it was within the window of time.
It was within the window of time.
Motion? And the motion is, we're talking 1405 for the amount.
Motion to approve the guarantee fund amount requested.
Second,
Second.
please.
Second. This is Linda, second.
Okay. Discussion? All in favor?
Aye.
Aye.
Opposed?
Aye.
Opposed?
Pass. Okay. All right. Thank you very much.
Okay,
Thank you.
Right, okay.
And Mr. DiCarlo, Mr. Sotire, I'll be in contact with you with next steps as well to let you know how this proceeds and what the next steps are.
Thank you very much, all.
Okay, sounds good. Thank you.
Thank you for your time today.
I'll be following up to you in reference to
Thank you.
the broker's action on this.
Mhm.
Is that it for today? Was there anything on the agenda that I missed? Guess that's it.
Let me know when you want me to talk again.
We'll bring it up as new business. All right, so go ahead, you're on.
Thank you very much. Unless there's some kind of objection, I'm going to move that we make Ben chairman and remove the term acting.
The last time we had a not an acting chair was Barbara Thompson. That was how many years ago? 10 years ago or more? Then we had Marilyn Keating, who was acting, and now we have Ben who's acting. So I agree with you, Barbara. I don't quite understand why we have acting chairs for so long.
I think it's because you have to be appointed by the governor. That's how we get around that. There'd be other actions we'd have to do to get appointed by the governor.
But what if we decide that you should be the chair and not acting?
I'm not sure we can do that.
I think we can try, and if we can get forgiveness if we're wrong.
Well, the reason why I'm saying we can discuss this for a moment, as you know, I've been on for going on 26 years on the commission. I've been the acting chairman. I forgot now. It's got to be about 8 years, I would say. And it's going to be at some time I'm going to not resign from the real estate commission and maybe want to step down from being the chairman or of such. But I don't really want to leave because it was left to me, and it's been left in the past, this position. People just walk away. Well, unfortunately, the person who takes it, there's a lot to know. I mean, it doesn't sound like there's a lot to know. We look at, but there is. And it's history really means a lot. So I would love if somebody wants to step up and be the chairman. I would stay with them as a co-chairman and work with them for a while. That's my feeling. And I've been meaning to discuss it because it's got, I'd feel bad if I just walk away and just dumped everything on somebody. It's been done before, and it takes a while to really catch on a little bit. And then it's nice to also go back on what did we do 10 years ago, 5 years ago, whatever. Those are my comments.
It was by default, Ben. Nobody else would take on the responsibility, and you were willing to do it.
Well, yes.
I mean, there's no problem with your trying to have another commissioner trained and ready to step in, but you could still do that as chairman. Doesn't prohibit you.
Well, I was a co-chairman. Remember when
That's me.
right. A while back, I was also co-chairman for Bruce Caginelli. Remember when Bruce was the chairman?
Yeah.
When Bruce was the chairman, I was the co-chairman there for a while. As you also know, not only am I on the real estate commission, I'm also on the manufactured home council. Okay, which we have as a commission, we have to have be on there. And I've been on that for over 20 years.
So
My
Ben,
only
if
question
you,
do you refuse or reject the offer of being chair? Because if you
No,
are,
I'm-
certainly.
I'm not
gonna
quite
push it.
sure what would change. I'm not sure what I would change. I mean, I never looked at it as a temporary position anyhow. But,
I think it would do two things. One, it would show that you have the full support of your fellow commissioners, which I think would be nice. The second thing is, I don't know whether, I mean, I think certainly the chair is, I think, perceived to be better than acting chair, because it's acting chair sounds like it's temporary, and this is certainly not temporary.
that's true.
Going back a minute to what
Can I
what
ask you
you're
a
talking.
question? Is there anyone here that would be willing to, would be interested to be a co-chair?
A question, Ben, have you talked to anybody about that, or do you have anybody in
I
mind?
have. It's been in my mind for a while, but I have talked to one individual.
Okay, because I have one person in mind too, but I'm not gonna volunteer her.
Mhm.
Well, can we take one thing at a time?
Sure.
So I have made the motion that we name Ben chairman of the commission. Do I have a second?
Second. The worst that could happen to us is the governor can say we can't do it. Right?
Right.
All in favor?
Aye.
Aye.
Motion passes. You are now officially our chairman, Ben, whether you like it or not.
Thank you.
I
Okay.
think you can deal with the co-chair aspect of it by talking to the people that you're interested in and then bringing that back before the commission. So thank you for the service of so many years that you've done this as acting chair.
So Ben, now that you've been acting chair, now that you know how to do the job, and now you become the chair, it means you got to stay on for another 8 years.
I think we should adjourn the meeting. How's that? Okay. Thank you all, by the way. And thank you so much for all your support. It's been great. Thank you.
Thank you.
Thank you. Bye, everyone.
Thank you, Ben.
You get a
Bye.
raise now, Ben.
Okay.
Are we adjourned? Thanks, Ted.